It's time for Right to Reside and Lifetime Interest Trusts. In under 3 minutes, let's get started. Wills are able to have trusts within them. These are called will trusts. At HoneyPro, we offer various types of will trusts at a click of a button. For this video, we are talking about two in particular, Right to Reside and Lifetime Interest will trusts. A Right to Reside will trust is a type of trust within a will, which allows the occupant named the authority to reside within a particular property that the testator owns. This of course only comes into effect upon the testator's death, and not before. The testator can also impose certain conditions that the occupant must abide by, if they wish to keep living in the property, for as long as they wish. As standard, Right to Reside trusts have conditions attached to them, such as not being able to cohabit, not being able to remarry, and the occupant must keep the property in a good state of repair. If the occupant doesn't conform to these conditions, the trustees within the will are able to terminate the right to reside, and the occupant must seek alternative accommodation. A lifetime interest trust has the exact same features and benefits as the right to reside, in that it allows a named person, in this case the life tenant, to keep residing within a named property. In this type of trust, the lifetime interest lasts a lifetime, unless the life tenant breaks certain conditions, or wishes to revoke the lifetime interest. The lifetime interest trust also has the added benefit that if the property is rented out at all, after the testator's death, the life tenant has the benefit of any and all income generated by the property. Of course, the prerequisite to these types of trust is that the testator must have owned a property, or a share of a property at the time of their death. Especially in the case of the lifetime interest, if the life tenant is a spouse and the property is being passed to direct descendants, this type of trust can also preserve the right to apply for the residential mill rate band allowance, which adds another £350,000 to a married couple or civil partner's mill rate band allowance. There is no other work required for these types of trust, simply the clause within the will is sufficient. After death, the executors only need to simply transfer the legal ownership of the property into the names of the trustees, for them to manage on behalf of the occupant or life tenant. As you can see, these are very straightforward and simple trusts. If you are a property owner, this is the absolute minimum you should be considering for your estate planning needs. This has been Right to Reside and Lifetime Interest Trusts, in under 3 minutes. The next in the series will be our favorite estate planning solution, the Protective Will Property Trust. Like and subscribe to be notified when this goes live.